Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, equal protection tiers and protected classes. Let's begin. Equal protection is a classification doctrine. The government treats people differently, and the constitutional question is whether the classification is justified at the proper level of scrutiny. Most hard questions are not about reciting strict, intermediate, or rational basis review. They are about deciding whether the classification is facial, discriminatory in application, or motivated by discriminatory purpose, whether the affected class is suspect, quasi-suspect, or neither, and whether a fundamental right is independently burdened. The Equal Protection Clause of the 14th Amendment directly limits states and local governments. Equal protection principles apply to the federal government through the Due Process Clause of the 5th Amendment. State action is required. Purely private discrimination is not constitutional discrimination unless it is fairly attributable to the government. Strict scrutiny applies when the government uses a suspect classification or burdens a fundamental right. The government must prove the law is necessary or narrowly tailored to achieve a compelling governmental interest. Intermediate scrutiny applies to quasi-suspect classifications. The government must prove the law is substantially related to an important governmental interest. For gender classifications, the justification must be exceedingly persuasive and cannot rest on overbroad stereotypes. Rational basis review applies to all other classifications. The challenger must prove the law is not rationally related to any legitimate governmental interest. A court may hypothesize legitimate interests. Step 1. Identify the classification. Facial classification. The law classifies on its face, such as by race, sex, alienage, age, or residency. Discriminatory application. A neutral law is administered differently against a protected group. Discriminatory purpose and effect. A neutral law has a disparate impact and was adopted or maintained because of, not merely in spite of, its adverse effect. Step 2. Pick the scrutiny. Race, national origin, and ethnicity. Suspect, strict scrutiny. Alienage. Usually suspect for state discrimination, strict scrutiny. Gender and legitimacy of birth. Quasi-suspect, intermediate scrutiny. Age, disability, wealth, poverty, sexual orientation under traditional MBE framing and most economic lines. Rational basis. Fundamental rights, including voting, interstate travel, and certain access to courts' rights. Strict scrutiny if substantially burdened. Step 3. Apply the burden. Strict scrutiny. Government bears the burden. Most laws fail, but not automatically. Intermediate scrutiny. Government bears the burden. Means must fit the actual important objective. Rational basis. Challenger bears the burden. Most laws survive. Race and national origin. Any intentional racial classification by government triggers strict scrutiny, including classifications said to benefit minorities. Remedial racial classifications must remedy specific, identified past discrimination by the government actor or satisfy another compelling interest recognized by the court. Racial balancing for its own sake is not compelling. Alienage. State laws discriminating against lawful resident aliens usually receive strict scrutiny. Exceptions receive rational basis review under the political function doctrine when the position is intimately related to democratic self-government, such as police officers, public school teachers in some formulations, probation officers, or voting-related positions. Federal alienage classifications usually receive rational basis review because immigration and naturalization are federal powers. Gender. Gender classifications receive intermediate scrutiny. The government cannot rely on archaic assumptions about men's and women's roles. Real biological differences may sometimes justify tailored rules, but stereotypes cannot. Legitimacy. Classifications based on non-marital parentage receive intermediate scrutiny. Laws punishing children for parents' conduct are disfavored, but the state may impose reasonable proof requirements for inheritance or support. Discriminatory purpose. Disparate impact alone is not enough for strict or intermediate scrutiny. The challenger must show discriminatory intent. Evidence may include historical background, sequence of events, departures from normal procedure, legislative history, and stark statistical patterns. Fundamental rights. Equal protection can be used when a classification burdens a fundamental right. Voting restrictions, ballot access burdens, and durational residency requirements for essential benefits may trigger heightened review, depending on the right and severity of the burden. California's equal protection analysis under the state constitution often resembles federal analysis, but California may independently protect rights under its own constitution. On the California bar, however, the MBE answer applies federal doctrine unless the question expressly invokes California law. California also has robust statutory anti-discrimination regimes, including employment, housing, and public accommodation protections. Those are not the same as federal constitutional equal protection because constitutional claims require state action, while statutes can regulate private conduct. Note: if a California public university, city, county, or state agency classifies by race or sex, constitutional equal protection is implicated. If a private business discriminates, look first for statutory claims unless the facts show state action. Trap 1. Treating disparate impact as enough. A neutral exam, zoning law, or hiring rule with racial disparity does not trigger strict scrutiny without discriminatory purpose. Trap 2. Applying strict scrutiny to poverty. Wealth is not a suspect class. But if inability to pay blocks a fundamental interest, such as certain criminal appeals or access to divorce, heightened due process or equal protection concerns may arise. Trap 3. Treating alienage uniformly. State alienage classifications usually get strict scrutiny, but federal alienage rules usually get rational basis, and state political function jobs get rational basis. Trap 4. Confusing rational basis with no review. Rational basis is deferential, but laws based on bare animus against a politically unpopular group can fail even rational basis review. Trap 5. Forgetting affirmative action is still racial classification. A benign motive does not avoid strict scrutiny. Trap 6. Choosing equal protection when due process is cleaner. If the law applies to everyone but burdens marriage, contraception, family integrity, or bodily autonomy, substantive due process may be the primary doctrine. If the law distinguishes between groups, equal protection is central. A high-yield MBE STEM often says a city adopts a neutral zoning law that disproportionately affects one racial group. If the facts do not show discriminatory purpose, apply rational basis unless another classification or fundamental right appears. Statistical disparity alone rarely wins. Another favorite is a state law limiting public jobs to citizens. Ask whether the job involves democratic self-governance. If it is a notary, basic civil service job, or ordinary public employment, strict scrutiny may apply. If it is a police officer or comparable policymaking or coercive public function, rational basis may apply. Gender questions usually involve protective laws. Women cannot work overtime, men must pay alimony, mothers automatically receive custody, or one sex receives a benefit based on role assumptions. The answer rejects stereotypes and requires an exceedingly persuasive justification. A tax sequence. Is there state action? What classification exists on the face, in application, or by purpose and effect? Is the class suspect, quasi-suspect, or ordinary? Is a fundamental right burdened? Assign scrutiny and burden. Test fit. Necessary, substantially related, or rational. Exam payoff. The MBE rewards discipline sorting. Race equals strict scrutiny with intent. Gender equals intermediate scrutiny with no stereotypes. Age, wealth, and disability usually equal rational basis. Federal alienage is deferential. State alienage is usually strict and less political function. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.